Thank you everybody for coming. A very warm welcome to Caitlin and Victoria, who have come from top law firm Brodies to chat to us about all things estate planning. We're very, very grateful to them for coming. We know the last event we had like this was a couple of years ago, pre-COVID, and guests really found a lot of value from it, so we thought we'd do it again. So appreciate you coming down. And a warm welcome to all of you for coming. Ricky, thank you for representing the gents today.
The gents.
It seems like the ladies are thinking ahead. I'm sure about the rest. So this is all part of Leuchie's wider aim to increase awareness about legacy giving, giving a gift in your will to charity. It's something that a lot of charities are focusing on at the moment, and we feel like it's important for us to be part of that as well and to show the real benefit of leaving a gift to Leuchie in your will. That's not to say that anything that Caitlin and Victoria said today means you have to give a gift to Leuchie in the will. That's me, that's not Leuchie. But it's just to show you all the benefits of that and also how to get the house in order. So without further ado, I want to say thank you so much, and I'll let you begin. Thank you.
Thank you, Claudia.
Thanks, Claudia. As Claudia said, I'm Victoria. I'm a senior solicitor in the personal and family team in our Edinburgh office, and Caitlin is with me today, who's also a solicitor in our Edinburgh office, and we will be having a chat to you today about estate planning. So I'll pass over to Caitlin, who will tell you a little bit about Brodies to begin with.
So, yes, first off, who are Brodies? We are Scotland's largest law firm. We've got offices all over the place, in summary: Edinburgh, Glasgow, Aberdeen, Inverness, and a wee Brussels office for any sort of European post-Brexit work. We have 109 partners and 771 roughly colleagues. The major advantage of working at Brodies is that we have a lot of specialists across almost every area of the law, and that access to specialists is important. If you're coming to a private client, but also we can consult with litigation colleagues if needed. So that, I think, is the major bonus. And more specifically, the personal and family team within Brodies is, I think, in summary, brilliant. Really highly ranked, and just generally, nice to meet, lovely people to be with.
Okay, so a wee bit more about the personal and family team. We are Scotland's largest team of personal and family law specialists working within a full-service law firm. We have 15 partners working within our team, and that includes 3 new partner appointments since May this year. We are ranked Tier 1 for personal tax, trusts and executories in the Legal 500, and we're ranked Band 1 in the Chamber's High Net Worth Guide for Private Wealth Law with 6 individually ranked lawyers. We also have 16 members of the Scottish Trust and Executory Practitioners. So what does that mean for our clients then? Really, that means that we are best at what we do. We can be upfront with our clients about costs and timescales. We try to keep everyone informed at every step of the process, and that really means that we can give a bespoke service to our clients, because we listen to our clients' own circumstances and react to exactly what each individual needs. We are very friendly and approachable, and we like to think that our clients can come to us with any set of circumstances or background, and that we would be able to help.
So we're here to chat to you today about wills and powers of attorney. Broadly, a will, as you might know, is how you divide your assets. Hello. How your assets are divided on your death, and a power of attorney is about capacity. We'll come on to that a bit later. But the first thing to think about is, why should you make a will? Without a will, you don't have any say over how your assets are divided on your death. There are quite archaic succession laws which dictate how your estate would be divided, and it might not be quite how you would think it would be. So that's the main importance of having a will. But you also include, things about providing for your loved ones, guardians for your children, just to give you that peace of mind, that everything will be dealt with for your family as you want it to be. And the other advantage of a will is generally it's more expensive if you die without one to administer the estate. There's more court involvement, whereas if you've got a will, it's really quite straightforward. So who needs a will? Our answer is always everyone. But really, on death, a will becomes important if you've got a bank account, if you own a property, if you're married, separated or divorced, if you're cohabiting or single, or you've got children under 16. Now, I think the vast majority of people are going to fall into at least one of those. You might be sitting there going, I've ticked a few of those boxes. So, if you tick any of those, we'd be strongly recommending that you have a will.
So why would we recommend that you use a solicitor instead of a DIY will writing kit or a postal service kit? The main reason is that we can give you bespoke advice based on your own circumstances. No two people are the same, and therefore everyone's instructions will be different in that regard. It's worth getting it right. Caitlin touched on the fact that if you don't have a valid will in place, the costs and timescales of getting things dealt with when you die can be a lot more stressful for your loved ones. So it is really important to have it right in the first place. And the next thing is just really to touch on what happens when you don't have a will, or at least a valid will. Your estate would be divided in terms of intestate succession. So that is really quite an archaic, old-fashioned principle that doesn't really take account of many modern families, sort of second marriages and children from previous relationships and that kind of thing. You cannot ensure that certain assets pass to the people that you would want them to pass to. So, for example, thinking about jewellery or any sort of sentimental items that you would want your children or your sister to inherit, that wouldn't happen if you don't have a will in place that says that you want that to happen. You cannot appoint a guardian for children without having a will in place, so that's really important if you have particularly young children, to make sure that they're looked after by the people who you would want to look after them. And as Caitlin said as well, it can be much more expensive and time consuming when there is no will in place, because it does involve an application to the court to get someone appointed. And it is worth noting as well that as much as we don't like to think of it, family disputes do often arise, and we see it quite a lot in our day-to-day. So as much as people think, we all get on fine, it'll be fine, it doesn't always work out like that. So it is important that people do what they can to make sure things are in place and that it's dealt with the way they want it to be.
So Victoria touched on the fact that we do bespoke wills, and I think it's really important to talk about what that means. We see a lot of standard form wills, a sort of one-size-fits-all approach. That's not what we do at Brodies. We sit down, we chat to you about your circumstances, and then we think about what would work. And that's particularly important if your will would pass money to children who could be under the age of 25. If it would pass money or property to a vulnerable beneficiary, there's lots of things you can do for vulnerable beneficiaries, and that goes for disabled beneficiaries as well. And then there's sort of the marriage component to think about. If there's a divorce or a second marriage in the family, we would tend to structure things a bit differently. A lot of people have very different ideas of what is fair, or who might need the money, for example. You might want your ex-spouse to have the money to look after the kids, but you wouldn't want them to have full control over it. That's something we see quite a lot. So the sort of bespoke will becomes really important there, because we can tailor it to your exact family circumstances. And then the other element is sort of planning for the future, and we'll touch on care home fee planning and a bit about inheritance tax planning. It can be important to the same types and different types of people. And then quite importantly, in a will you can appoint guardians for your children. Now, a guardian is someone who, if you were to pass away, would take over the parental rights and responsibilities over your children. And a child is anyone under the age of 16. So some teenagers who will insist that they're not children anymore, nonetheless this does apply to them. And that can be a really difficult decision. It might be parents that you want to appoint, it might be your own friends, aunts and uncles, cousins. We do a lot of talking to people about who might be suitable. And there's always an age dynamic there as well. You know, would you want to appoint your own parents, or you know, someone who would be able to help with bringing up kids can be really important. And then there's the individual or the couple idea, because whoever is the guardian will have to work with whoever the other guardian might be if there's another one. So thinking about that dynamic can always be really important. You don't want to create a situation that's difficult on everybody. So just generally planning ahead for the guardian appointment. And then the other sort of major thing in a will is funeral instructions. Now this can be as detailed or as vague as you want. Quite often we see a decision about cremation or burial. The major point that we like clients to include is this arrangements on death declaration, and it's about who you would want to decide, because we see, you know, obviously death is a really emotional time. It can be quite traumatic, and the family often just want to do what they think is best. So we focus on, you know, who should make that decision, and that can be, it can be one person. You could appoint, you know, all your children together to make the decision, but just, you know, I think it provides a lot of reassurance to the family to know what, say, mum or dad wanted. And then we've also seen the, you know, the more complex instructions. We can help write a letter of those, you know, hymns that you want, or whether you want religious service, where it should be, that kind of thing. We do a lot on funeral instructions.
Okay, so the starting point from our point of view is that everyone should have a will, and that they should be reviewed regularly. Quite a lot of people will put a will in place and think, you know, I've dealt with that, it's done. But circumstances do change, and they change more often than what people would imagine. I wanted to have a bit of a chat about life events and what the type of things that might change your circumstances enough to warrant at least a chat with a solicitor about changing your will. So divorce being the first one there, an ex-spouse would be automatically treated as having died before you on your death. But obviously divorce can have a bearing on your financial circumstances, and if there's children as party to that divorce, then you would want to think about legal guardians and, you know, what happens to the children, or whether you want to ring fence money to pass directly to the children on your death after a divorce. Another thing to think about is the breakdown of a relationship. So this would be in circumstances where a couple quite haven't got divorced, but are in the process of doing that. That can be quite a lengthy process sometimes. So we would always advise that you put a will in place at the time of separation, and that could be reviewed once the divorce has gone through, because quite often it makes sense just to have something in place for that duration until you can finalise and see where you stand. Another thing that we wanted to mention was about providing for a cohabitant. So this is known as a Section 29 claim, and this can only be available where a deceased person died without leaving a will, and someone cohabiting with them can have a claim on their estate. Now, they must be cohabiting as husband and wife or as civil partners at the time of the death, and there's really, really strict timescales for doing that. So there's a 6-month deadline. Quite often that's not long enough for confirmation to be granted, or probate, as it's sometimes known as, to be granted in the estate. So it is really important that people know of these issues. And the other thing to mention is that can be really costly. Again, it's an application to the court and would result in solicitors being involved. So if it's something that, you know, you are cohabiting with someone, or someone in your family is, it's worth them having a think about whether or not they would want to provide for that person on their death, and just setting that out under the terms of their will is the most simple way to do that. Okay, so the next thing to think about is inheritance tax. So in terms of the basics, in the UK you would be taxed on your worldwide assets at the date of your death. Each individual has their own nil rate band. That is currently £325,000. It has been that rate for many years now, and that's unlikely to change in the near future. There is also now a residence nil rate band, which I'll talk a bit more about that in a minute, but that is currently £175,000. You have to meet certain criteria to qualify for that part. But basically, as a general rule, anything that you own over the £325,000 limit would be taxed at a flat rate of 40% for inheritance tax. There are certain reliefs available, and that percentage can change in certain circumstances, which we'll chat a bit more about. And one main thing to note is that if you leave everything outright to your spouse or civil partner on the first death, then that is a tax-free transfer. There's a spousal exemption there, so that wouldn't apply. When that would kick into play is then on the second death of a couple. That nil rate band could be transferred from the first person to the second person, so you would have a total of 650,000 there to leave tax-free. So the residence nil rate band applies to any deaths after the 6th of April 2017, so it's still a fairly new concept. The current rate is £175,000, and that only applies where you own a property at the time of your death and you pass that property or pass your estate to your direct descendants. So that is children, adopted children, grandchildren, anyone that follows down that line. And again, that would be transferable on the second death. So what that means in real terms is that if you are a married couple or a couple in a civil partnership, and you've got your residence nil rate band of 325, your partner's nil rate band of 325, and the two residence nil rate bands, you can leave £1 million tax-free. Anything over and above that would be charged at 40% as a general rule. And if you have over £2 million, then the residence nil rate band side of things tapers off by £1 for every £2 over that limit. So it does dwindle down at that stage as well.
So if inheritance tax is something that you would need to think about, so really, and as Victoria's pointed out, this is couples with a total estate anywhere over £1 million, including your house, that kind of thing. There's a lot you can do. A lot of clients like that. Our very first piece of advice is spending money, buying things, cars, cruises, anything that feels like throwing your money away. Brilliant inheritance tax planning. The other major gifting strategy that we see is gifting to family. There's all sorts of rules around it, but as a general rule, gifting to anybody is a good idea for inheritance tax purposes. You have an annual allowance of £3,000, so you can gift £3,000 per year without incurring any tax charges or any tax consequences. In addition, if you make any gifts to anyone more than 7 years before your death, tax-free, no issues. If you gift money within 7 years of your death, they can become chargeable to tax, but maybe not at 40%. So really, if you made a gift sort of 7 years before, the rate's likely to be quite lower. If you made it 2 days before your death, the rate's likely to be around the 40% mark. So generally, gifting early is the best way forward. And that's obviously subject to keeping enough money for yourself, that you need for all your expenses and your yachts and your cruises and that kind of thing. And then there's more particular exemptions. So normal expenditure of income is one that we see for usually living allowances. If you're paying for a child to go to university or that type of thing and you're paying the same amount every month, that can be exempt, although definitely chat to a solicitor about that one because there's sort of rules and regulations about it. And then charitable giving, so any gifts to charity during your lifetime or on your death in your will are completely tax-free. And that, I think, can be really, really important and a sort of added incentive if you're planning on doing it anyway, to know that there's no tax consequences, there's no barriers to doing it. And then the other big planning that we see is gifting into a trust. So the general rule is that gifting into a trust does result in an immediate inheritance tax charge, even if you're doing it during your lifetime. But every 7 years you can make gifts of £325,000 without incurring a tax charge. So sometimes we see people putting £325,000 into a trust every 7 years. And you can start that planning, in your 60s or your 70s, or you can start it when you're 40. We see, both sides of that. And then a bit more on the gifting to charity point. So, as I've said, gifts to charity during lifetime and on death, and it's worth saying it's quite a wide definition of charity, and if there's anything in particular you're thinking about, we can look into it a bit more, but broadly anything that is a registered charity, tax-free. And then there's an additional benefit. So if you leave more than 10% of your personal estate, and that's setting aside trusts and everything, if you leave more than 10% of that to charity, then the rate of tax on your remaining estate will be 36% rather than 40%. And we can do the maths on that. It's not something for you to worry about, but that can be an added benefit. And for some people, gifting that extra money to charity can actually result, because of the lower tax rate, in more money being available for your other beneficiaries, so your family, your kids, cousins. So there's definitely a bit of planning to do there. And the calculations are our problem, not yours. And then I said earlier on that the other thing we're here to chat about today is powers of attorney. So I think before we chat about what it is, it's worth saying, why on earth do you need one? So what a lot of people don't realise is that if something happens such that you can't make decisions for yourself, and the example we always use is ending up in A&E unconscious, your spouse or civil partner or cohabitant and your children, none of them have any rights to make decisions for you if you don't have a power of attorney in place. And that can come as a surprise to a lot of people. A lot of people think, well, obviously I'd want my wife or husband to make the decision, but without a power of attorney they can't do that. On top of that, having a power of attorney in place, effectively you set out what you want to happen ahead of time. You retain your autonomy, you retain your control. And our advice is that everyone should have one regardless of age. We are maybe not the most cheery talk you'll ever have, but anything can happen. And that's why we say everybody should have one. So when might you use a power of attorney? There are two types. There's what's called a continuing attorney, which is a financial one. So that's anything to do with money. And then you've got a welfare attorney, which is really everything that you would think of as being care related. So it's where you live, what you wear, who you associate with, what kind of clubs you do. That all comes under welfare, whereas financial is more, who can talk to the bank for you, who could think about selling your house. So a financial power of attorney can be used as soon as it's registered, and the one we often see is, for example, maybe someone quite elderly, still has capacity, can still make decisions, but struggles to physically get to the bank. They appoint power of attorney for their husband and or their children, and then the children can talk to the bank for them. We see that quite a lot. And then on the welfare side, even if the power of attorney is registered, a welfare attorney can't make decisions that you can make yourself. So capacity is a sliding scale. If you can still decide what you want to wear in the morning, your attorney cannot make that decision for you. But say it's a really complicated decision that you maybe are struggling with, then your attorney can make that, but they've also got a duty to help support you to make the decision. So a welfare one's more of a grey area, and we do a lot of helping people with that. And then you decide what your attorneys can do at the end of the day. We generally recommend that you put wide powers in, because these are people that you trust. At the end of the day, it's major decisions you're asking them to make. But we can restrict the powers if you want. But yeah, definitely talking about the powers is the first step.
So what happens then if you don't have a power of attorney and you lose capacity and cannot make these decisions for yourself? That would result in a family member or a friend, or sometimes a social worker, if there's no one else, to make an application to the court for guardianship. Now that is a really lengthy, cumbersome process that can take, you know, up to a year to get that in place. So imagine a situation where suddenly something happens and you can't make these decisions for yourself, no one else has the legal authority to do it, and you've then got to go through this process of medical assessments and suitability reports to make sure that the order is exactly what's needed. What that means is in that interim time, no one has the legal authority to help you or to help make decisions for you. That can vary from different councils. It depends on availability of mental health officers and things like that, but generally speaking, you're talking at least probably closer to the 12-month mark at the moment, especially post-COVID with delays and working from home and things like that. And the other thing to mention is that is very expensive when compared to the cost of putting a power of attorney in place. So it's definitely something that we recommend that all clients do, is to have a power of attorney in place before it gets to that stage, to try and prevent needing to apply for a guardianship order. Another thing that we wanted to mention was about care costs planning. So we quite often get asked questions from clients about, you know, elderly clients might say, I want to give my house to my children so that I don't have to pay for care. Now there are really strict rules about all of that, and gifting can be considered deliberate deprivation of assets. And what will happen is the local authority will look back over previous years and previous gifts made, and they can claw back if they think that those gifts have been made with the intention of avoiding care home fees. There is no limit on how far back they can look. That's quite a common misconception as well, because there's a 7-year rule for tax on gifting. Quite a lot of people think that they can't go any further back than the 7 years, but they can, and they do. So that's definitely something to think about. You can use trusts, and there's different types of trusts and different ways to do that. It's not always recommended, and sometimes the professional costs involved for setting up a trust and continuing to administer that and to meet the ongoing annual compliance can outweigh the benefits of that. And again, if it's considered that that's been done as a deliberate deprivation by the local authority, they can look back to that as well. A much better way of planning for care costs is doing it in terms of your will. So what that often looks like is for a married couple maybe to leave everything, or your share of everything, directly to the children or in a life rent trust for your spouse, so that then if you die first, your spouse still has the use of all of that, but it can't be clawed back because it's left outright to your children at the end of the day. So that would at least ring fence and protect half of your combined estate for care costs.
I think at the very beginning, before we started speaking, Claudia used our stock phrase, getting your house in order, and that's definitely how we view these initial will and power of attorney meetings. It's about taking a sort of wholesale look, you know, taking stock of what assets you have, thinking about your care for the future and providing for all of that. Our sort of, you know, if we were to put it in a checklist, this is what it looks like. We recommend that everybody has a will, a power of attorney, that they've thought about funeral arrangements. It doesn't need to be in your will, it can be a letter to your family, you know, in the bureau that you've told them is there. That's what my grandparents have gone for. The other big thing to think about is pensions, life insurance policies and death and service benefits. Pensions, I think for a lot of people, are one of those things, they maybe know they have one, they have not the foggiest how it works, how much it's worth. We get a lot of, and here are my pension papers, make of it what you will. We, you know, are more than happy to take a look and have a think about whether there's anything that should be done with a pension. It's worth saying most pensions aren't subject to inheritance tax, So that sort of scary 1 million figure we were talking about doesn't include your pension, and that can become really important because for a lot of people their pension is their most valuable asset. But there's still a bit of thinking and planning to be done with pensions. And then the other major thing for people who own their home is where the title deeds are. If you bought your home really recently, it's quite likely that it's registered electronically. But if you bought it, 20, 40 years ago, it's very likely that you've got paper deeds. The best scenario there is that they're held with another solicitor. We would recommend that you get it all under one roof, the same place as your will and power of attorney. And that can take a bit of tracing, especially if the solicitor firm doesn't operate anymore. The other situation that we sometimes see that we definitely don't recommend is storing your title deeds in your own house. If you think about that, the title deeds are about proving that you own a piece of land and that you own a house. If you have a fire in that house and the title deeds are destroyed, that's not ideal. So we recommend that you put all of these things in storage. We've got an off-site storage facility. But that is really what getting your house in order looks like.
Okay, so in terms of next steps, we're more than happy for you to contact us. We'll put some contact details up at the end. As Caitlin said earlier, we have offices in Edinburgh, Glasgow, Aberdeen and Inverness. We can also now take instructions for wills and powers of attorney by video call, which is quite often preferred these days, post-COVID. We would be happy to meet you at Leuchie House or at home. There might be additional charges for either of those options, but it's certainly something that we can do, and as friends of Leuchie House, then there would be a discount for using Brodies as well. I think if you just put the next slide, that should give our contact details there. So at this point, we'll say thank you to everyone who joined us on the Facebook Live, and if there's any questions from that, do feel free to get in touch afterwards and we'll help as best we can.